Ready, start. By this writ application under Article 226 of the Constitution of India, the writ applicants, residents of village Vandi, Tuna, district Kutch, have prayed for the following reliefs: to issue a writ of mandamus and or other appropriate writ, order, or direction directing the respondents to ensure that the fishermen of Vandi village Tuna are able to access the sea without any hindrance, and that all hindrances created as a result of the activities of the respondent number 5 company be removed forthwith, to issue a writ of mandamus and or any other appropriate writ, order, or direction directing the respondents to immediately remove the illegally constructed railway line and do all that may be required to restore the mangroves in the region, to issue a writ of mandamus and or any other appropriate writ, order, or direction directing the respondents to ensure that all the blocked creeks are opened and that the free flow of water is maintained in the region for development of mangroves and to protect whatever mangroves are left, to issue a writ of mandamus and or any other appropriate writ, order, or direction directing the respondents to remove all the construction development that has been erected without permission of the relevant authorities, to impose exemplary penalty on the respondent company for willfully and knowingly breaching the environment laws, to direct the respondent company to compensate the fishermen in the region, to pass any other and further order that may be deemed fit, proper in the facts and circumstances of the case. We have heard Mr. Narendra L. Jain, the learned counsel appearing for the writ applicants, Mr. Mihir Joshi, the learned senior counsel appearing for the respondent number 5, Adani Kandla Bulk Terminal Private Limited, Mr. Devang Vyas, the learned additional Solicitor General of India, appearing for the respondent number 4, Ministry of Environment and Forest Government of India, and Mr. Dhaval Vyas, the learned counsel appearing for the respondent number 6, Deen Dayal Port Trust. This litigation in public interest has something to do with the difficulties faced by fishermen of village Vandi, Tuna, and other surroundings villages on account of development that has taken place in the area at the instance of the respondent number 5. The village we are talking about are all coastal villages. It is the case of the writ applicants that earlier village Vandi was right on the shore. However, with the developments that took place over a period of time, the shore is now a distance of about 7 kilometers. According to the writ applicants, the only means of their livelihood is fishing, and as on date The entire fishermen folk are finding it extremely difficult to reach up to the sea as they have to travel almost a distance of 7 kimis. Mr. Jain, the learned counsel appearing for the writ applicants, pointed out that as on date the fishermen are at the mercy of one individual who owns a plot which is right on the shore. This individual is kind enough to permit the fisherman to stay at his plot. In other words, it is easy for the fishermen to travel into the deep sea in their respective boats from the plot owned by a private individuals. According to Mr. Jain, there is no dispute as regards the fact that substantial development has taken place, which includes two railway lines, roads, etc. It is virtually impossible now to disturb all these constructions. However, the villagers of this village expect the state or any other authority to provide them some access from their respective villages so that without any hindrance or obstruction they can straightway reach up to the shore. This litigation is now 3 years old. Only two respondents, that is, the respondents number 4 and 5 respectively, have filed their reply. Mr. Jain pointed out that he has filed a rejoinder, but the rejoinder does not seem to be on record. According to Mr. Joshi, the learned senior counsel appearing for the respondent number 5, the entire writ application filed in public interest is frivolous. Mr. Joshi would submit that whatever has been argued today by Mr. Jain as recorded above does not form part of the pleadings. In the absence of specific pleadings, it is difficult for the respondent number 5 to meet with the exact case put up by the writ applicants. Mr. Joshi would further submit that there does not seem to be any substance in the grievance of the villagers as regards the difficulties caused so far as access to the sea is concerned. According to Mr. Joshi, the construction which has been undertaken is in such a manner that at no stage the float of water is blocked. Mr. Devang Vyas, the learned Additional Solicitor General of India, would submit that as such the Ministry of Environment and Forest Government of India has no role to play so far as the present litigation is concerned. Mr. Vyas pointed out that the main respondent who would be in a position to assist this court is the respondent number 2, the Gujarat Coastal Zone Management Authority, for short the GCZMA. It is this authority who has granted all the permission so far. Mr. Dhaval Vyas, the learned counsel appearing for the respondent number 6, Dindayal Port Trust, would submit that his client also has no role to play. We take notice of the fact that this matter was taken up for the first time for hearing on 9th May 2018. A coordinate bench of this court issued notice, but the same was restricted only to the respondent number 2. It seems that as on date no notice has been issued to the state of Gujarat. We are of the view that the presence of the state of Gujarat